Let's talk about evidence. Five-part evidence test. We started with relevance, right? The definition of relevance. Does it tend to make a fact of consequence more or less likely? If it does, then that's the definition of relevance. The definition of material is that it must be a fact of consequence to the lawsuit. What type of evidence have we seen that falls into this discussion about relevance and material? Remember the cases on statistical evidence. We tend to think of relevance as needing to get us up here, but when we admit evidence, all we have to do is show that it has any tendency to help make a fact of consequence more or less likely. Whether it's a civil or criminal case, the standard is, does it have any tendency to help prove or disprove a fact of consequence? That is a very low threshold in order to admit evidence. So when we looked at those statistical evidence cases, it's not enough. You don't need to show 95, 97, 98. Or you might not even need to show it's more likely true than not true. But that's a pretty good way to think about it, is that when we're admitting evidence, even statistical evidence, when we looked at those blood grouping cases and we looked at the possibility that was blood and all the others there with respect to statistics, we don't have to do it to the point where we disprove any other possible consequence. All we've got to do is show that it has any tendency to help prove or disprove a fact of consequence. When it's a recreation and the like, what makes it relevant? Again, we're not expecting that anyone would be able to show the exact replication of the earlier conditions. All you've got to do is show it's substantially similar to the actual event to offer a fair comparison such that now it becomes reasonable and relevant to admit that evidence. Same type of thing when we start to think about, well, what other evidence have we looked at that's either relevant or not relevant? Character evidence, right? We talked about character evidence. The fact is, in almost all civil cases, character evidence is not considered relevant. Why? Because it doesn't go to any issue in the case. Unless it's a libel or a slander case, under those circumstances, then the person's character, what people think of that person, is relevant, certainly on the issue of damages. But in all other civil cases, it's not an issue. And even in the criminal cases, where character evidence may be relevant, it's not relevant until the accused opens the door. How does the accused open the door? By offering relevant character evidence, relevant to the crime charged. If you're being charged with a violent offense, then you can open the door by calling witnesses who know of your character for peacefulness. If it's an offense involving excessive use of drugs or alcohol, you have the ability to offer evidence through those witnesses who know of your reputation for not imbibing in alcohol or using drugs and the like. Relevant character evidence, but only after the accused opens the door to it. And so if they don't, it's simply not a relevant issue. And if they do it, it's got to be related to the crime charged in order to be admissible. The similar events, we talked about brides in the bathtub. We talked about other occurrences that can come in if they are relevant. What makes them relevant to the present case? Because they go to one of those issues about motive, opportunity, intent, common plan, scheme, design, lack of mistake, or identity. If they do not, they simply are not considered relevant evidence. They don't have any tendency to help prove or disprove a fact of consequence. And even if there are prior events, if you're trying to say that they go to common plan, scheme, or design, one event isn't going to do that. Multiple events would tend to show common plan, scheme, or design. Lack of mistake or accident may well be an event or one or two events, but when we talk about common plan, scheme, or design, in order to make them relevant, then what you've got to do is be able to show multiple events somehow from your past tie you to that present event. Couple of other related issues as you start to think about relevance is the relevant scope of cross-examination, which we've talked about on multiple times. Under the Federal Rules of Evidence, what's the relevant scope of cross-examination? Be C, D, right? Bias, credibility, and the subject matter of the direct exam are the proper scope of cross-examination under the federal rules. Bias, that you have a stake in the outcome of the case, that you are a party's mother, brother, lover, means you have a bias to testify favorably for one party or the other. The fact that you have been paid to testify, as most experts have, gives you a bias, right? Character, C, credibility, bias, credibility, and direct. Every witness, every case, when they promise to tell the truth, have opened up that area, whether they are considered a truthful person, for inspection. How do we attack the witness who takes the stand, their character for truthfulness? We can attack it in a variety of ways. One of which you know is we attack it through their prior convictions, right? If they have crimen falsies less than 10 years old, no discretion to exclude it. Once they testify in any case, I have the right to ask them and inquire about their prior convictions less than 10 years old that are for crimen falsies. Any crime where fraud or deceit is an essential element of the crime, that's fair game. Their prior, and not just the crimen falsies, but other felonies I can inquire about, but there the court has a balancing ability to exclude the prior convictions if they're not crimen falsies less than 10, and what they're going to look at is if it's a witness to make sure that if they're admitting it, it passes the test of not being substantially more prejudicial than probative, and if it's the accused themselves conviction, it can be excluded simply upon a showing of more prejudicial than probative. Once it gets more than 10 years old, for every witness, all of those crimes go into the same mix. There must be advance notice of your intention to use it, and the court has to find for all witnesses, including the defendant, it is substantially more probative than prejudicial. So the test switches over so that there's a tendency to exclude criminal convictions that are more than 10 years old because they're too remote from the present event. But your criminal convictions, whether we're talking about testifying in a civil case or a criminal case, are likely coming in under this rule, and they are absolutely coming in if they deal with crimen falsies and the conviction is less than 10 years old. Your character for truthfulness when you promise to tell the truth can be attacked. One way, very common way, is through prior convictions. Another way is through your prior inconsistent statements, right? If a witness has gotten up here and told us one story, but there's another story out there, their prior inconsistent statements are coming in. We'll talk about it a little more when we look at the hearsay as part of the 5-part test. Their prior bad acts that are probative of truthfulness, I can inquire about on that cross-examination. Again, they've opened up their character for truthfulness an issue, and even prior unconvicted bad acts are now fair game. I can ask the question, but that's where the inquiry will end because I am not allowed to introduce extrinsic evidence of those prior bad acts. Character for truthfulness. I can put other witnesses up there to say that you're known in the community as a liar, a dishonest person. Your character for truthfulness in every case is now fair game. D, direct, the relevant scope of cross-examination, federal rules of evidence. B, C, D. The D is direct, what you just testified about, and not just the minute-by-minute pieces of what you testified about, but the subject matter of what you testified about. We read cases where the government said, well, they can't use different portions of the tapes, they can only use the ones we did. They can't talk about other events between these parties. Yes, they can if they deals with the subject matter of the direct exam. Whatever that subject was is now fair game on cross-examination. As are your deficiencies at either perking and testifying, right? You didn't wear your glasses, you should have. That goes to your ability to observe accurately. The fact that you have a head injury that might impair your understanding goes to your ability to be able to both perceive and then relate the events in question. Perception, understanding, recollection, and communication, which we're going to talk about in a minute, and under competency, is all fair game on cross-examination as well, to show maybe you don't remember it exactly as you think. There's a couple of other things to think about relevance. We have some rules, we're going to see them closer to the back end, where the fact that you offered to plead guilty and made statements during that, the fact that you offered to settle a case and made statements during that, the fact that you have insurance, the fact that you offered to pay medical expenses, almost all of those are covered by specific rules, which under the policy says none of that's relevant. For all intents and purposes, none of it's relevant as to prove negligence or culpability or liability. You may be able to help to use those for other events, but the fact is we want people to take subsequent remedial measures, make unsafe conditions safer. We want them to resolve their civil suits. We want them to engage in those discussions. And for the most part, for policy reasons, none of that information is likely considered legally relevant and admissible during the court proceedings. Let's talk about competency. Competency. And this is a simple analysis. PERC, right? Can the witness perceive, understand, remember, and communicate? Remember the cases we read. If relevance is a low threshold for admissibility, so is perking, right? Think of all those competency cases where really the only person that was excluded as a competent witness was the old woman with the knee. Every other witness, regardless of how significantly their ability to do one of those four things was limited or impaired, nonetheless got to testify. And so don't think we get perfect witnesses in the real world. We don't get them in any world, okay? And if you remember that line of cases, the poor guy was competent to testify even in his own incompetency proceeding. And that tells you two things. Again, the testifying threshold is ridiculously low, but also competency to testify is very different from being competent out in the real world. And it's a case-by-case, fact-by-fact basis that you have to make an analysis of. I said to you before, you could be an otherwise competent witness, but ingest too much alcohol or drugs or just be so out of touch that you didn't realize what was going on and can't testify about whatever it is took place that we need the testimony about. You need to look at the specifics to see if the person can perk and is allowed then to testify. If a lay witness is allowed to testify, they get to testify about what they know, right? What they have personal knowledge about. We don't care what a lay witness thinks. We don't care about their opinion because it's not sufficiently informed under the law, so we don't allow them to tell us their opinion except for 5 S's, right? Speech, speed, signature, sobriety, and sanity. You're going to have to lay the foundation that the person has some awareness, some personal knowledge about this, what the speech sounds like, what Professor Coyne's voice sounds like. Speech, speed of a vehicle, that you know what a vehicle looks like going fast or slow. But it goes beyond that because you can even testify as to specific miles an hour. Speech, speed, signature, that you have some underlying familiarity with one of your classmates or your partner's signature, handwriting. And you can attest that that's, having seen it, you know what it is, and that's there. Speech, speed, signature, sobriety. We all know what drunk or sober tends to look like. And the last of it is sanity, right? Sanity, that the person wasn't in their right mind, was acting crazy. Beyond that, the lay witness doesn't get to testify. They don't get to tell us what they think in testifying. They have to tell us what they know. If we're going to ask someone to tell us what they think, then that would be an expert witness. In order to classify as an expert witness whose testimony will aid the jury's understanding of the event, then that person has to have some combination of background, education, experience, and training such that that skill set will aid the jury's understanding of the event, that it will be helpful to them. And we read a bunch of cases where it was a question about whether this is beyond the ken of a lay jury. Should we get some help in testifying about someone's facial features and the recognizing that person from then the video surveillance? Should we allow the jury to make a decision about whether the top of the skull was hard or soft? Is the jury capable of doing those things, or do we need the assistance of an expert who, because of their skill set, will aid the jury's understanding of the event? And the fact is that as long as it will, and some combination of those four factors, background, education, experience, and training that person possesses, then we allow them to testify and tell us what they think. They could be competent even to offer their opinion in that regard. And as I was discussing it earlier with Steve, if you think about those four, there's overlap there, right? I mean, is background and experience, is there going to be areas where that overlaps? Without a doubt. And what about education and training? Same type of thing, right? It's a nice mnemonic, and it works to be able to remember it. But what we're really looking at there is sort of the whole body of what you bring to the table, and whether any one of those might, in essence, in and of themselves, be enough that your testimony will aid the jury's understanding of the event. It's the likelihood, it's the combination of your whole body of work that should ultimately get you to be able to be classified as an expert and allowed to testify and tell the jury what you think. But if it's science, it's got to walk and talk and act like science in order for you to be a competent witness. And post-Daubert, the test for whether science really is science is 4 P's and a T, right? It has to be based on, if what you're telling us isn't junk science, and that's where this came from, the test says, then you're going to tell us that if it's science, it walks and talks and acts like science. It must be based on 4 P's, principles of science. That it must have been published, right? We're going to look at it to make sure it withstood the test of what scientific matters must do. That it had to be published, that it was based on principles of science. 3rd P, peer review. 4th P, that the potential for error was examined. And the T is that it was subject to some form of testing. It's no longer enough simply to show that it is considered reliable in some parts of the scientific community. You're going to have to show that if you're saying and you're going to testify that this is some form of science, that it's got to meet the tests of what scientific information must go through. And even if you can satisfy us that the expert's testimony will aid the jury's understanding of the event, and even if you're saying it's science and somehow this will pass the test for science so that the jury can be instructed on this scientific information, you still don't get to testify as the expert on the ultimate, what we call the ultimate issue rule. But what that really means is the ultimate legal conclusion. So the expert who does your accident reconstruction can talk about all the testing and how they went down there and looked at it. They can tell us all about their physics degrees and all their practical experience and everything else. They can even put the little mathematical formulas up there and tell us how all of this is based on science and accident reconstruction is. But at the end of the day, while they can say that the defendant was exceeding the speed limit, crossed into the plaintiff's lane of travel and caused the collision, that's a factual conclusion. They cannot testify to the ultimate legal conclusion that that makes the defendant negligent. That's the ultimate issue, and that's reserved for the jury's province. And what it's considered to be is you're invading the jury's province if you allow the expert to testify to the legal conclusion. They can testify to the ultimate factual conclusion, however. If we're talking about experts, then those experts have to be sufficiently vetted through background, education, experience, and training to be allowed to testify. And under those circumstances, they would then come in. There are other things that make a witness incompetent to testify about things. Privileges, right? Privileges, there are various privileges where they must be asserted. Privileges can be waived if you don't assert them. We have a marital privilege that we've talked about. Partners to a valid marriage have the ability to preclude the other from testifying about confidential marital communications, even post-divorce. So generally, when we're looking at testimony from another spouse as to whether they're competent to testify about it, we look at whether we're asking the witness to testify about a communication or everything other than a communication, what we oftentimes call the observation of transaction rule. If one spouse is being asked to testify about a confidential marital communication, it was done in confidence, it was done while they were married, and it was a communication, the rule is either can prevent the disclosure of that information forever. If, on the other hand, it's an observation that we're talking about asking the partner to testify to, must be a criminal case, and the marriage must be in existence at the time of trial, and if it is, they are not going to be likely competent to testify in that criminal proceeding. State court either can prevent that person from testifying. In federal court, it belongs to the witness spouse. That's a marital privilege. You know, we've discussed the attorney-client privilege. Again, the client is the holder. If the client exercises that privilege, there can be no competent testimony with respect to confidential communications that took place between the two. Some witnesses, they have an imperfect memory when they get up there. I could say most. And the question is, well, what happens if they become unsteady in their testimony during the course of it? May a witness's testimony, who is otherwise competent to testify, be refreshed while they're on the stand? And you know the answer is yes, it can be refreshed, and it can in fact be refreshed through anything. Anything can be used to refresh a witness's recollection. The only issue that then comes up is if the refreshing takes place prior to taking the stand, you don't have an absolute right to examine what was used to refresh. If the refreshing takes place while the witness is on the stand, you have a right to examine what was used to refresh the witness's recollection. Doesn't involve hearsay problems, doesn't really even involve competency issues because the witness is saying, oh, now I remember. But it is sometimes come up as we start to think about competency. Can the witness's recollection be refreshed? And the answer is yes, and what can be used is virtually anything can be used to refresh recollection. What I said with respect to marital communications and marital testimony. If we're talking about getting testimony from partners to a valid marriage, at any point in time they were partners to a valid marriage, the first rule you ask yourself about is, are we asking that person to testify about a confidential marital communication? If it was, and it took place, it was confidential, took place during a valid marriage, and it was a communication of any sort under the federal rules, the rule is either can prevent the disclosure of that information forever. Doesn't make a difference whether at time of trial we're married or not. We're protecting the confidences that were disclosed during a valid marriage in confidence. Either can prevent the disclosure forever. If, on the other hand, we're talking about anything other than that, then it's a different rule, okay? Must be a criminal case, and the marriage must be in existence at trial. This is a rule of disqualification. What it says is that we don't want spouses having to testify against the other because that doesn't make for a happy marriage. And so if the marriage is in existence at trial and it's a criminal case, In state court, either can prevent the disclosure of that information, any testimony whatsoever, and in federal court, that right belongs to the witness spouse. In essence, the witness isn't going to be allowed to testify because either state court either can claim it, federal court, the witness spouse chooses not to testify and in essence offer evidence against their spouse. But that's the rule is for that part of it, they must be married at trial. If there's no marriage, there's no protection for anything other than confidential marital communications. Okay? Let's talk about foundation, because we touched on this as we started to think about experts. Foundation simply means that there's a valid basis for the admission of this trustworthy testimony. That's what you're laying the groundwork for here, is you're saying that the testimony is sufficiently trustworthy such that we should admit it. How do you know? Because I'm going to tell you where it came from and why it's considered reasonable and the like. The more trustworthy you can establish the evidence to be, the more likely we're going to find a way to admit it. And that is what you should be thinking about. That's what the rules are designed to do. Trustworthy evidence gets admitted. Untrustworthy evidence under the rules tends to be excluded. So how do we make it more trustworthy? Or how do we at least indicate to the court there's a greater sense that this evidence can be trusted? It's with the foundation. It's with where did it come from? What's its source? How did it get there? What is it? Why should it be trustworthy? The big area where this comes in is with expert testimony that we talked about. The more significant the qualifications are, the more scientifically reliable and accepted the theories that underlie this testimony are. That's all foundational requirements. The more you can show that, the greater likelihood the court is going to accept it, with the expectation that it will aid the jury's understanding of the event. Foundation makes it the basis for why the jury or why the fact finder should entertain the evidence, but it also is the precondition to saying why it's so trustworthy that you should admit it. And so as you think about that foundation, think about it because it doesn't come up just with respect to experts. It comes up with respect to a lay witness's observations of the speeding car, right? How far away were you? How long did you have an opportunity to see the vehicle? Was there anything in your way? You think about it from the standpoint of being able to lay a foundation such that we say it's built on a solid core, just like your house, right? Should withstand the test of time then, to the extent that you lay that foundation. What's the foundation for photographs to be admitted? It's simple. You got to show us it is what it purports to be. Not very difficult, but that means that we will need a sponsoring witness for photographs. Photographs, videos, these other things do not speak for themselves. Someone has to lay the foundation for who the speakers are, how we know those, how you know those are the speakers, and how we should then trust your version of who's in the picture and what's depicted, and then we can take a look at the photograph ourselves or the video. But they do not speak for themselves. They need a sponsoring witness, and that sponsoring witness is required to lay the foundation. Best evidence. Best evidence rule. The foundation for offering the documentary evidence is that it is what it purports to be, right? That here is the original. The rule is when you're proving the contents of a writing, recording, or other document, you must produce the original unless you can adequately explain the loss of the original. That's the best evidence rule. What it's designed to do is make sure that we don't have documents that have been genuinely altered, that this is what actually took place. And if you're offering that evidence, then you've got to produce the original unless you can adequately explain why you can't. And the federal rules have a relaxed best evidence rule, which says photocopies generally are as admissible as the original unless there's a genuine charge to authenticity. Unless you really, really have an ability to say in some manner that document has been altered. If you can, then the photocopy, you're going to have to tell us why we know that that's as good as the original. Also, with respect to the federal best evidence rule, not only must there be a genuine charge to authenticity, but you're also going to have to show that this is a matter of central importance. If it's somehow a collateral issue that isn't that significant, the court isn't going to get bogged down with your best evidence charge because they want to get to the meat of it and resolve the matter. Let's take a look at hearsay. Hearsay, you know the definition. Any out-of-court statement offered to prove the truth of the matter asserted therein is hearsay, unless or except. Let's take the first part before we get to that. Any statement made by anyone, anywhere, other than while testifying in this proceeding right here. An out-of-court statement. My notes are statements. Books, writings, affidavits are statements. It's not just what I say, right? We all agree those are statements, and we'll nod our head like this, which is a statement, right? Well understood gestures are statements. Assertive conduct. What aren't out-of-court statements? The clock, the radar detector, the breathalyzer, the blood alcohol reading, right? Machines don't speak. Only humans speak for the statements. And out of court, the court part is easy. Out of this court, right here, right now, is out of court. Out of court. So even statements made in an earlier court proceeding related to this case are considered out of court for our definition, yes. So we said, he said is going to be an out-of-court statement. Sounds like it coming an out-of-court statement. She said, out-of-court statement. Even I said. And that one messes a lot of judges and others up. But even I said, is it an out-of-court statement? Yes. So we have to go further with our analysis. Out-of-court statement. And we know it covers a wide range of things. We've seen it a bunch of times. And it's not just what I say, but it's an awful lot more than that. Out-of-court statement offered to prove the truth of the matter asserted therein. And that's the one that always gets a little more hinky. So what does that mean? Offered to prove the truth of the matter asserted therein. Well, the first thing, and we've talked about this, what it doesn't mean is that it's helpful to prove my case, right? That I need this to prove my case. That really gets much closer to a definition of relevance, doesn't it? Does it tend to help prove or disprove a fact or consequence? That's that standard. Offered to prove the truth of the matter asserted means you're offering it to prove the contents of whatever that statement is. If you're not offering it to prove the truth of the contents, it isn't hearsay, right? So I say Lindsay is a thief. Lindsay is a thief. She sues for defamation. She decides to, who can she call? Anyone who heard it, right? If we're going to offer it in, someone with personal knowledge can hear it. We don't need